Hello everyone. We are going to look at UPSC CSE 2022 Prelims Polity questions, and wherein we will also look at few governance questions. Talking about the difficulty level, most of the questions were easy to medium difficulty levels, which can be solved from the conventional sources. There were few questions which could not be done with the help of conventional sources, and we will look at all those questions. So let's begin. Let's start with question number 1. Question number 1 is, consider the following statements. Statement 1, pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. So this is conventionally not taught. This is conventionally not present in the most of the sources. Let's look at the second statement. The Constitution of India empowers the Supreme Court and the High Courts to punish for the contempt of themselves. We do study this one, and the power of these constitutional courts, that is the Supreme Court and High Court, come from the fact that they are a court of records, and the power of court of contempt is related to the power of the constitutional courts to be the court of records. So this one is right. The third statement, the Constitution of India defines civil contempt and criminal contempt. So no, Constitution of India does not define civil contempt and criminal contempt. In fact, this division has been given in the statute, the ordinary law, that is the Contempt of Courts Act 1971. So statement 3 is wrong. Next statement, in India, the parliament is vested with the powers to make laws on contempt of court. So this one is correct, and we have this Contempt of Courts Act. So despite not being aware of H.N. Sanyal Committee, we can come up with the answer, and the answer will be B. Moving forward, the next question in the polity series is, with reference to India, consider the following statements. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. Quite a difficult statement, but let's see what we can do with it. Government law officers and legal firms are recognized as advocates. When we see that legal firms cannot write exams and they cannot clear the exam conducted by the Bar Council, and hence they cannot be called advocates. If you apply this logic, this one is eliminated. So we can eliminate A, we can eliminate C also. Let's look at statement number 2. Statement number 2 says, bar councils have the power to lay down the rules relating to legal education and recognition of law colleges. We have Medical Council of India, AICT, All India Council for Technical Education, and we have ICAR, Indian Council for Agriculture Research. So we do have councils which have power to lay down rules and relating to legal education and recognition of law of colleges. So going by this logic of Indian Council of Agriculture Research, MCI and ICAR, we can say the statement 2 is correct. And looking at the fact that legal firms cannot clear the exam conducted by the Bar Council, only the individuals can, and hence the answer is B, that is 2 only. Moving forward, looking at next question. Next question is this. Consider the following statements. So the first statement is, a bill amending the Constitution requires a prior recommendation of the President of India. That is the first statement. Second statement is, when a Constitution amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent. Third statement, a Constitution amendment bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority, and there is no provision for joint sitting. So statement 2 and 3 both are correct. A bill amending the constitution requires a prior recommendation of President of India. We do not study this one. So this is a knowledge based question, and statement 1 can be eliminated on the basis of the knowledge which is imparted in the classroom and which is there in the standard sources. When a constitution amendment bill is presented to the President of India, it is obligatory. Yes, it is obligatory, because during the time of Indira Gandhi government, Article 75 was amended and the term shall was used, and hence shall means obligatory, that it becomes obligatory for the President to give his or her assent, and hence this Article 75 and the Constitutional Amendment Act becomes the reason that this statement is correct. Moving forward, looking at question number 14, which is the next question in the series. Let's read out the statement. Statement 1. The Constitution of India classifies the ministers into 4 ranks. Visually, Cabinet Minister, Minister of State with independent charge, Minister of State and Deputy Minister. The fact is, the Constitution of India did not used to even use the term cabinet, and the Constitution of India does not classify the ranks of ministers. In fact, Article 77 of the Indian Constitution allows the executive to come up with the rules and regulations for the allocation of business, and pursuant to that article we have allocation of business rules 1971. In full, it's called Government of India Allocation of Business Rules 1961, and therein we have the hierarchy and the classification of ministers. In Constitution of India per se, there is no classification. The total number of ministers in the union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. During the time of Atal Bihari Vajpayee government, this rule of 15% was imposed via Constitutional Amendment Act, and hence this statement is correct. All right. Next question. Next question is, which of the following is or is the exclusive power or powers of Lok Sabha to ratify the declaration of emergency? We know that emergency is declared jointly by Lok Sabha as well as Rajya Sabha, that is Parliament as a whole. So this one is wrong. Looking at statement number 2, to pass a motion of no confidence against the Council of Ministers. Motion of confidence or motion of no confidence, this takes place inside Lok Sabha and not Rajya Sabha. It is said that the executive is responsible to the Parliament in general and Lok Sabha in particular, and hence this is the differentiating and exclusive power of Lok Sabha. To impeach the President of India? No. During the impeachment, both Lok Sabha and Rajya Sabha are involved. Both the houses are involved, and hence we have the answer as B, 2 only. Next question in the series. With reference to anti-defection law in India, anti-defection law is Schedule 10 of Indian Constitution, which was originally not there but has been added into the Constitution via Constitutional Amendment Act. So we are talking about that. The law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the House. In fact, law does specify about a nominated member joining a political party, and the upper limit for that is 6 months. That is, a nominated legislature can join any political party within 6 months and not after that, and hence statement 1 is wrong. Statement 2, The law does not provide any time frame within which the presiding officer has to decide a defection case. So, this statement too might appear correct because of the recent judgment of Supreme Court. The Supreme Court has been saying that the presiding officer should be deciding the cases within 6 months or within 3 months or within reasonable period of time, but there is no such time frame given in the law itself. All right. So, only statement 2 is correct. The law does not provide any time frame. Yes. So, answer is B, 2 only. Next question. Cut. Start. Question number 17. That is the next question. Consider the following statements. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. So, Attorney General of India is a constitutional office, and the Attorney General of India has been allowed to participate in the proceedings of the Parliament, both the houses. They can discuss, debate, participate, but they cannot vote. So, they have all the rights, they have all the rights and privileges. They even have the permission, the given permission of the Constitution of India to participate in the parliamentary committees proceedings also. But such kind of power has not been given to the Solicitor General, only the Attorney General. All right. According to the Constitution of India, the Attorney General of India submits his resignation when the government which appointed him resigns. It generally does happen that the tenure of Attorney General of India is coterminous with the party which has appointed him, but it is only a convention. It has nowhere been mentioned in the Constitution. He, being the senior most legal officer of India, is appointed by the President, and he generally resigns when the party in power changes. So, both the statements are incorrect. Moving forward, looking at the next question. With reference to the writs issued by the courts of in India, consider the following statements. Mandamus. Mandamus is a type of writ. In fact, writs are mentioned in Article 32 as well as Article 226. The writ jurisdiction of Supreme Court is there in Article 32, and the writ jurisdiction of High Court is there in Article 226. Different kind of writs are mentioned, however, but the definition has not been mentioned, and that is where the standard reference sources come into picture. That these are the important terms like mandamus and writs, which are mentioned in the Article 32 but has not been defined. So, despite the absence of definition in the Constitution of India, we still teach in the classes, and the definition is present in all the standard sources also. So, mandamus will not lie against a private organization. This statement mandamus will not lie against a private organization unless it is entrusted with a public duty. So, mandamus is against a public organization, judicial bodies, tribunals, or the public bodies or public officials. Mandamus will not lie against a company even though it may be a government company. This will not lie against a company even though it may be a government company. Any public minded person can be a petitioner to move the court to obtain the writ of quo warranto. Yes, any aware citizen of India can move this and this is against usurpation of public office by an individual. So, answer will be C, 1 and 3 only. Or let's have a look at this statement again. Mandamus will not lie against a company even though it may be a government company. No, if the company is acting for the government or if it is a government company, so this is there, it comes under the public body. Even a private body which is working for the government, for example, let's say a public project, let's say National Highway Authority of India is building roads, but the contract has been given to a private organization. So, for the purpose of that project, it will be treated as a public body. So, I think that is the clarity about statement number 2. Let's look at this question. With reference to Ayushman Bharat digital mission, consider the following statements. This is not a core polity question. This is governance question. This is health governance and e-governance. So, Ayushman Bharat has been among the biggest pioneering projects which the government of India has undertaken, and this has been in the news for quite some time. The digital aspect of it has been in the news for the past couple of years. In fact, Niti Aayog is working big time on the digital economy and the digital governance and national health stack. So, let's look at this. Private and public hospitals must adopt it. So, maybe not immediately, but ultimately, that is a plan. As it aims to achieve universal health coverage, every citizen of India should be part of it ultimately. This is visionary and this is correct. It has seamless portability across the country. So, if 2 is correct, then 3 also has to be correct. And this is information based question, current affairs based question, and the answer is all 3 are correct. All the statements are correct, and hence the answer is D. Let's look at the next question. The next question reads, with reference to the Deputy Speaker of Lok Sabha, consider the following statements. This was there in the news. Statement 1, as per the rules of procedure and conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. This appears true on the face of it. This appears correct on the face of it. Let's read next statement. There is a mandatory provision that the election of a candidate as Deputy Speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. There is no such mandatory provision which is taught in the class or which is there in the constitution. So, this is not correct. Statement 2 is not correct. Statement 3, the Deputy Speaker has the same power as the Speaker when presiding over the sitting of the House. This is taught in the class and this appears logical also. So, this statement is correct. The last statement says the well-established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Speaker and duly seconded by the Prime Minister. There is no such provision which is taught, and this doesn't even seem logical. All right. So, as per the educated guess, you can eliminate this one, and the answer will be 1 and 3 only, A. All right. Looking at the polity and governance question, this is what we have as the next question. If a particular area is brought under the 5th schedule of the Constitution of India, scheduled areas are 5th and 6th scheduled areas, which is conventionally taught in the class, which is also there in the standard sources. So, which one of the following statements best reflects the consequence of it? This is slightly tricky, in the sense you might be confused between the statement A and a statement B. Let's read it. This would prevent the transfer of land of tribal people to non-tribal people. So, this is taught in conjugation with Forest Rights Act, which was again in news for the past many months, and in fact this has been constantly in the news. Statement B, this would create a local self-governing body in that area. So, this would create a local governing body in that area. Yes, local governing body is created, but not in that area. This is created at the state level, and that is known as Tribal Advisory Council, and this is not created at the state level. This would convert that area into a UT, completely illogical. Yes, because when we look into the details of 5th and 6th schedules, we know that this is not a provision. We also look into the fact how the union territories and for what purpose union territories are created. You will see that this is completely illogical, and this statement C makes no sense. Statement D, the state having such areas would be declared as special category state. Special category state. Such areas are there in a cluster, smaller clusters within the state. So, because of those smaller 1 or 2 clusters within the state, the whole of state cannot be declared as a special category state, and hence statement D is incorrect. We are left with, by the method of elimination, we are left with statement A as the most appropriate option, because we have eliminated B because the local self-governing body is created at the state level, that is the Tribal Advisory Council, and that is actually not a governing body, that is advisory in nature, and hence the answer is A. This would prevent the transfer of land of tribal people to non-tribal people. So, that is all in polity, and the level of difficulty, barring one question or two questions, is same as the last year, and polity has been largely conventional. And talking about the $1 million question, which is the whole cutoff, we will have a look at it after we are done with discussion of all the sections. So, on an informal note, the cutoff is going to be close to the previous year cutoff. The reasons and the detailed logic will be given by us little later after we are done with this. So, that is all from my side in the polity and governance section. All right, thank you.